Welcome to Nurture Small Business, Creating a Thriving Space, with your host, Denise Kagan. Denise is the president of DCA Virtual Business Support and has been a business owner for almost 20 years. DCA Virtual Business Support provides small businesses with an expert pairing of virtual administrative and marketing assistance to match your needs. Learn more at dcavirtual.com.
Hello and welcome to Nurture Small Business Podcast, the business ideas podcast for growing your 6- and 7-figure income businesses. Now, I have a guest here with me today that I'm not going to introduce in the typical way. Noel Bagwell has been on my podcast before, and his first segment was done in September of 2020. We have a small audio clip that we're going to play from that podcast. If we could go ahead and get that audio clip going now.
I would ask them, why didn't you hire a lawyer in the first place? And that sort of leads into the next part of my story. But the answer to them, for them, was a lot of times cost. It came down to, or they thought it was cost. It really wasn't cost, because I would say, why didn't you hire a lawyer in the first place? And they'd say, well, I can't really afford it, yada, yada, yada. And I said, well, you're paying hundreds of dollars or thousands of dollars for litigation expenses. You can ill afford that, but would you have paid this number, much less, to prevent this from happening? And they're like, well, yeah, of course. In hindsight, sure, I definitely would have. And I said, do you think that's less expensive than you thought it would have been had, on the front end? And they said, yeah, definitely. So I definitely would have paid for that. And so I started thinking about the question, why don't people hire lawyers to do preventive legal work for them?
Absolutely. That was an incredible podcast called Legal Poverty. You can catch it on our podcast page, dcavirtual.com/podcast. And without further ado, Noel, welcome to the show today.
Hey, thanks for having me on. I appreciate it.
No problem. So I didn't do the traditional intro, so I do want you to give our audience just a little bit about your background.
Yeah, my name is Noel Bagwell, and I operate Executive LP, or Executive Legal Professionals PLC. We're an innovative virtual law firm located in Nashville, Tennessee. All of our clients are entrepreneurs and small to medium businesses. I'd say our ideal client has somewhere between 10 million and 50 million in revenue, but we help a lot of much smaller businesses, including startups as well. And our core offering is profit from legal. It's legal operations installation. Basically, we've recently scaled it down. We had initially planned to launch it over about 6 months, but now we've scaled it down to a 2-month program focusing on the essentials of legal operations for small businesses, basically aligning general counsel and legal support with your enterprise goals for even a small business. So that's the name of the game. It's basically showing you how to use legal services in order to become more profitable, and helping you, not showing you how to do it and not doing it for you, but doing it with you, like actually implementing those systems and processes, and all the other things that you're going to need in order to use legal services to make your business more profitable. That's the core of what we do, but we also provide, business formation and outside general counsel service to small businesses.
And Noel, you host a podcast as well. Is that correct?
Yeah, we have the Profit from Legal podcast. It's been going since January 17th of this year, so it's still relatively fresh. We just hit 2 months on St. Patrick's Day, so that's pretty exciting. We've already been heard in 6 countries.
Nice.
Have a couple thousand impressions on the podcast, and it's been a lot of fun to create that content and talk out loud and develop ideas out loud with the guests that we've had for the interview episodes, and also just to think through and share with our audience some of the ideas that we've had as we're developing Profit from Legal. I mean, our core offering is still, while it's available, it's still very much in development as well. We're always trying to tweak and fine tune things and just always make that client experience better.
So a funny little story, when Noel first told me the title of his podcast, I was like, is that Profit, Prophet? And he said, no, Profit.
Yeah.
It's like, which makes far more sense. But the creative side of my brain went in a totally different direction.
It's funny though, we do a lot of risk forecasting. So I mean, there is kind of a profit. It's not quite biblical, not that kind of profit, but there is a bit of forecasting that's involved with your legal support, and that's why it's so important to involve your lawyer early and often in business decision making processes and discussions in your business, because unless you do, it's difficult for them to help you with the forecasting that can really prevent risks from becoming problems, which would then become crises in your business.
And that kind of rolls me into some of our Q&A. So we've had some questions submitted ahead of time, but I would also ask our audience, if you have any questions, to please go ahead and put that through chat. And then Rebecca will give me cues whenever we have something in there. So the very first question is, okay, my company has a voice over IP phone, and we got hacked and wound up with $30,000 worth of out of country calls. Who's responsible?
I would say that comes down to the terms and conditions of the agreement with your VoIP provider. Typically, you're not responsible for things like I think about an analogy being like credit card fraud, right? If someone steals your credit card number and they run up a bunch of charges, typically because of the regulations that pertain to credit cards and the credit card agreements themselves, combination of those things, the cardholder doesn't ultimately bear responsibility for that. Proving that you were hacked, demonstrating that it wasn't you, that you didn't actually incur the charges, and that you behaved in a commercially reasonable manner in terms of how you were employing your VoIP service, that you weren't being negligent, you weren't being reckless with your login information, and you weren't sharing it with people you weren't supposed to share it with, and that sort of thing. I think if you cross the commercial reasonability hurdles and you kind of show that you've done everything in the appropriate way, you used it the way you were supposed to, but through no fault of your own, someone else hacked in, used the service, and ran up a bunch of charges, I would think that a good VoIP provider would credit those charges back to your account. I would refuse to pay it. I certainly, like, if they are sending you a demand for payment on the account for things that you didn't use, charges that you didn't make, calls that you didn't make, I would just refuse to pay that. Be very clear about what happened, and refer that you need to get a lawyer. You need to hire a lawyer and have them work on this matter for you. Basically, have them handle the dispute. But my position, at least initially, would be, I'm not responsible for those charges. I'm not going to pay it. The only exception to that would be if based on the terms of your agreement with the VoIP provider, if that contract says that you are, if it expressly says that you're liable for charges such as those, then that's what you agreed to when you signed up for the service. So it really does matter what those contracts say, even though it's pretty common for most people to just click, yes, I agree, I accept the terms and conditions, without reading it at all. And when that happens, when you do that, there can be real world consequences. So it's a good idea to be familiar with the terms and conditions of use. Without knowing the particulars of which company it was, what the agreement says, that sort of thing, I can only speak in generalities here. I can't give you any legal advice per se. I can just kind of set an expectation for you, but typically I would say that there's a way to resolve that dispute without having to pay the full bill.
I have a follow-up question to that. So
Sure.
What would that corporate responsibility, because you mentioned that, what is that in layman's terms? What does that mean?
Yeah, to be commercially reasonable means to do things in a way that is reasonable for a business of your type and size, that you're following sort of industry best practices. When it comes to confidentiality, like maintaining the confidentiality of passwords, account data, user account data, and so on, it basically means protecting those things in a way that is reasonable. Like, could you have done this and it wouldn't have been prohibitively expensive. It wouldn't have been unduly burdensome for you to use a different password for every account, like not using the same password for every account, to use a password keeping software system like 1Password is one. I'm not endorsing 1Password. I'm just saying, yeah, LastPass. PassPack is another one. There are a bunch of them now, right? But are you using one of those to manage a password management platform to manage the passwords for your business? And are you not sharing your passwords outside of that platform? So every member of your team ought to have their own unique login for that platform. And then you ought to have within the platform password sharing capability. And so that should really be the only way that people are sharing and accessing passwords. They should not be emailing a password to somebody that would give access to, especially one that would give access to all your passwords, confidential data. You basically want to protect things in a reasonable way. And when we say commercially reasonable, what we mean is taking into account the nature and the size of your business, what the risks are, and all of that. Commercially reasonable is, and just reasonable in general, is a somewhat subjective term, but it's like a Ron Seal brand, right? It does what it says on the tin. Commercially reasonable is just exactly what it sounds like.
Okay. And so then you talked about passwords, and it's really funny because I advise my people all the time. It's like, okay, if it's your child's middle name, get rid of it. We tell our clients all the time, do not email passwords. So that's why you kind of got a chuckle out of me when you were talking about passwords and password keepers and not emailing them. Okay, so next question. If a client mails a check and it's not received, yet it gets cashed somehow through theft or other illegal activity, who's responsible to replace those funds? Would the business owner have to make a claim to collect the funds, or is it, where does that fall? Because if you're mailing a check for $3,000 as a small business owner, that's going to be a very big hurt if I am not able to get those funds.
Yeah, I would say that you need to report the fraud to your bank is the first step, right? You need to basically have the funds reversed back into your account, and you need to report the fraud to your bank and allow them to investigate it and go through their whole process for that. You need to go to your bank and say, what was the scenario? You wrote a check to somebody else, so you were the payer. You're not receiving a check, you're paying it.
I believe it was if a client mails a check to a business. Okay. But it somehow gets cashed, but it's not by the business.
But not by the business. So you're the recipient of the funds. Okay. So someone's paying their bill effectively or whatever. They're paying an invoice or they're paying some money. And you're telling them, hey, look, I haven't received your payment yet. And they say, well, we sent a check. If you're the business, the appropriate answer to we sent you a check or the check is in the mail is we didn't receive it. And it's not, with all due respect, it's not really our job to make sure that we receive funds. It's our job to receive the funds when we receive them and to properly process those payments and things. But it's your job as the customer to make sure that we receive the funds. In contracts for purchase and sale, for contracts for services and so on, there should be a notice clause in each of those agreements. And the notice clause should say that like written notices and payments and stuff have to be sent a certain way. Sometimes that's certified mail or whatever. There are also payment processing clauses or payment methodology clauses that you can insert into contracts that say you need to make payment in this particular way. Payment by check is one of the worst ways to receive payment anymore. There just really isn't much call for writing a check. I mean, having your bank electronically send out a check through bill pay or something, that's better than you like physically writing a check like it's still the 80s or something and you're sending out this check to somebody. But we strongly encourage people to set up a wire transfer, an ACH, some sort of automatic bank to bank payment to prevent exactly this sort of thing. But if you find yourself with a customer who's saying, the check is in the mail, or we sent you the check and I don't know why you didn't receive it. For one thing, I would be very, very skeptical as the business. I mean, the check is in the mail is like one of the most commonly heard lies in business ever. So I would just kind of roll my eyes at that. And then I would say, well, you need to report to your bank. And if you're saying that the check was cashed, it wasn't received by us and we didn't cash it. So you need to report the fraud to your bank and work with your bank to get those funds put back in your account. Meanwhile, late fees and whatever other, if there's late fees, interest, and all of that is starting to accrue on your account. So you need to make an alternative payment. Would you like to pay with a credit card over the phone today? Would you like to make an ACH payment over the phone, an e-check payment, wire transfer? Can we set up some kind of less susceptible to fraud payment method for you? And that's, if I was the business owner, that's how I'd handle it.
And at what time would it be appropriate for them to involve legal counsel? If it's needed at all.
For the recipient?
For the business to collect those
funds. The business should already have legal counsel. The business should have ongoing legal support, ongoing preventive legal support from before they make their first sale. You should have a lawyer. You should have outside general counsel or in-house counsel, depending on the size of your business and what you're doing. You should have that day one and forever thereafter. So you should call your general counsel and say, hey, we have a potential collections issue. There's a client who was supposed to have sent us a check for, what was it, $3,000 or $3,500, whatever it was. They were supposed to have sent us a check for $3,000. They're saying that they sent the check and that the check was cashed. We never received the check. We've double checked with our bank. It's not been deposited into any of our accounts. Nobody in our office says that they've seen it. And so we don't have any real reason to believe, we don't have any evidence to believe that anyone at our business or organization received this check and cashed it into the business's accounts or otherwise. So for as far as we're concerned, the customer is not telling us the truth, or they haven't made the payment or whatever, but they owe us the money and we need to receive the money, and it doesn't matter whether or not they've sent it really. What matters is whether or not we received it. So bring that to your lawyer's attention, ask them for their advice, and let them advise you on what the next steps are for you in your jurisdiction and all of that. I would suspect most lawyers to say, let me send them a cease and, or not a cease and desist letter. Let me send them a lawyer letter, like a collections letter that says, you owe us this amount. You have 10 days to pay it, or we're going to take legal action to enforce our rights to payment. And by the way, if it's payment for an ongoing service, your service is suspended until we receive the payment. And please contact our billing department or this person who processes billing for your business at this phone number immediately to work this out. They'll be professional, they'll be polite, and that's really what you should do. Is you should have your lawyer handling collections matters like that. And that's like really the initial phase right there of a collections matter, is just doing a polite professional reach out to the client saying, it's our job to get paid. It's your job to make sure we receive the payment, that it's sent to the right place. And by the way, if you have written a check and mailed it to us and it's been cashed, you need to report that to your bank, because that's fraud. We never received the check. We never caught it, and let the bank sort it out. Hopefully the bank will be able to get those funds back in the account and they'll be able to pay you.
Okay, so the sender has to report it as fraud. As far as the business goes, contact the bank.
Oh no, the business should not. Yeah, if the business is sending funds to somebody,
okay,
and if the business is in the payors, so the payor is the person making the payment, the payee is the person receiving the payment. If you're in the payor position, you're making the payment, and you send a check to a business, and they say, like, say a business to business transaction. Like, let's say I hire a marketing firm to do some marketing for me, and I write them a check for $5,000 for marketing services. And I write that check and I put it in the mail and I send it. And I see on my online banking that check was cashed, right? I should also be able to see the scan of the check and who endorsed it, and, other things that will help me play detective and figure out, was this properly received and cashed? But if then the other party is telling me, the marketing firm is telling me, we never got your check for $5,000. You still owe us $5,000. We never got your check. we haven't cashed that check. Then my first call after I hang up with them is to my bank to report fraud and say, look, I wrote $5,000 check to a marketing firm. They're saying they never received it and that they don't have the funds and that I still owe them that. But I'm seeing on my online banking that that check was cashed. So I assume it was intercepted somewhere along the lines and someone fraudulently cashed that check. So I'd like to report this to fraud, to the bank for fraud.
Great, thank you. So I'm going to invite our guests one more time that if you have any legal questions related to small business, please put those through chat. I do have one more that was sent to me in advance. So I serve clients in multiple states. Which state's laws prevail in regards to the agreement where the client is located or where the company is located?
If there is a written agreement, if it's a well-written agreement, the agreement itself will state that. It will say, and there will be a clause that says governing law, this contract is governed by the laws of the state of whatever. It will also have a jurisdiction clause and venue clause, and it'll say, the jurisdiction or governing law is pretty much the same thing, but it'll also have like a venue selection clause that will say something to the effect of, if either party sues the other party in this suit, then the exclusive or non-exclusive jurisdiction venue for that lawsuit is courts in this particular city or state. So for example, it might say under governing law, this contract is governed by the laws of the state of Tennessee. And then under venue and forum selection, it might say if either party sues the other party, then the only place where that lawsuit can be brought is Nashville, Tennessee, Davidson County, in any federal or state court that has jurisdiction in that city and state. And there's a case on point with this. It was a Carnival Cruise Lines case. There was a couple in Washington State who took a cruise. I think it was out of Seattle or somewhere, but in Washington State at any rate. And the wife fell and broke her hip, I believe it was, on the ship. They got into some choppy water. She slipped, broke her hip. It's very sad. And of course, when they got back, they wanted to sue Carnival Cruise Lines for not putting out, caution tape or, a caution sign, or not basically doing what they believed that the cruise line should have done to assist them in preventing that kind of a slip and fall accident. And Carnival said, you can't sue us here in Washington. You have to sue us in Florida, on the other end of the country. We're going from the extreme northwest to the extreme southeast part of the country. You have to sue us in Florida because our ticket sale agreement, our passage agreement, or whatever they call it, says that you agree to bring any lawsuits against the cruise line in the forum that's most convenient to us, which is where our headquarters are located in Florida. And the court upheld that. So they dismissed the case in Washington and had to bring it again in Florida, or they vacated it from one court to the next. So your contracts should say, if you don't have a written agreement, then if you're a business in, doesn't matter, New York, right? But you've got a customer in Pennsylvania and the customer doesn't pay you for services rendered, you should sue them in Pennsylvania, not in New York. And the reason is that their property and where they are, their person, like all their stuff and everything that you would be trying to seize, to sell, to pay any judgment that you get, their bank accounts, all that stuff, that's all in Pennsylvania. So you want to sue in a forum that has jurisdiction over their money and over their stuff, so that if you get the judgment and they don't pay it, then you can take post-judgment collections actions to seize property, sell that property, pay the judgment out of the proceeds of the sale. So you basically always want to bring the lawsuit in the state or the jurisdiction where the defendant is. Now, it gets a little complicated, but stick with me. You can, if your contract says you must sue or you must bring the lawsuit in this other jurisdiction, and that the other person agrees to that in the contract, say, same facts, you're in New York and your customer is in Pennsylvania, and you have a contract that says that the lawsuit must be brought in New York City, in New York State, in any federal or state court, in that jurisdiction, and they agree to that. then you can sue them where you are in the forum that's convenient for you, just like Carnival Cruise Lines made that couple sue them in Florida. You can bring that suit there, but then you're still going to have to do what's called localizing the judgment. You're still going to have to go, once you get the judgment, and take it to the jurisdiction where the defendant is, localize the judgment, but basically bring it and say, look, we have this valid judgment from this other state, and that state, in this case under our fact pattern, Pennsylvania, will recognize the judgment of the Court of New York and allow you to do the post-judgment enforcement, post-judgment collections action based on the judgment that you got in New York. But you're still going to have to hire a lawyer in Pennsylvania to go and do the post-judgment collections work. So it can get a little hairy. My recommendation is always have a well-written contract, which means drafted by a lawyer, not some template that you downloaded off the internet and hacked together yourself. Have a lawyer write your contracts, and always have them include a governing law or jurisdiction and venue clause. They also need to include a clause in there about attorney's fees. So, in any lawsuit that's related to the contract, the prevailing party should be entitled to collect attorney's fees from the non-prevailing party. So the loser pays the winner's attorney's fees effectively.
Oh, okay. That's interesting. I've heard you in every single answer refer back to the agreement and the contract. So I just want our listeners to be aware of that. So I do have a couple of questions that have come in from Daniel. The first one, I'm a consultant working with nonprofits to help them develop sustainable programming. What are the legal parameters involved with nonprofits providing services to corporate sponsors of the nonprofit?
Okay, that's that. There's some vague language in the question that requires a bit of unpacking. So if you're a consultant and you work with nonprofits, I presume that means that you are an independent contractor working for the nonprofits, not as an employee, but as an independent contractor. When you ask what are the legal parameters, that's not really a meaningful question. But let's see, I'm going to interpret that to mean legally what is involved. Legally speaking, what is involved when the nonprofits are providing services to corporate sponsors of the nonprofit with respect to your programming. You're on, right? Can you clarify a little bit and just kind of tell me a little more about what's happening without giving away too many details?
Yeah, no, sorry to be so vague.
It's all right.
So I know I am of the opinion that nonprofits can and should be charging for products and services.
Excuse me one second. So Daniel, we are going to be posting this publicly. So you are on video and you are talking. I need your permission.
That's okay.
Okay.
Yeah. That nonprofits can and should be charging for products and services in order to become more sustainable. But I know that the legal parameters around that can be complicated. In order to maintain a tax-exempt status as a nonprofit, charging for products or services can get messy. So the nonprofit that I'm working with is attempting to create strategic partners with a variety of for-profit organizations. And with those partnerships, if they engage in like a sponsorship agreement with a for-profit organization, I know that prohibits or limits the nonprofit from providing value of at least what I was reading, 2% or more of the cost of the sponsorship. So I'm just really confused about how that arrangement works. Does that make sense?
Yeah, a little bit more. I get it. I get what you're asking a little more. So my general advice to people who are in this dynamic is if you're an independent contractor of the now, when you talk about sustainable programming, you're talking about the programs, and you're not talking about software programming. You're talking about like curriculum and different activity programs, right? Okay.
Yeah.
So I would, since you're an independent contractor, you need to have your own lawyer that advises you about your legal rights and what your rights and responsibilities are with respect to the nonprofit. the nonprofit needs to have their own lawyer, and the for-profit company or companies that are involved also need to have their own legal counsel. And all those lawyers should be talking to each other about the sort of nexus of legal rights involved here, because there are some potential conflicts of interest here, and having one lawyer advise multiple parties in that situation gets really hairy in terms of conflicts of interest. So that's the conflicts of interest is the first legal issue to address. The second issue is, what I'm really hearing you'd be concerned about is the loss of nonprofit status for selling goods and services that might be considered more of a for-profit company activity. If the for-profit company is what's called a low-profit limited liability company, or L3C, it might be less problematic. Their low-profit limited liability company and partnerships or interactions with nonprofits have a bit more grace from the IRS in terms of 501c3 status. That's all I'm really going to say. I'm going to keep it kind of vague, intentionally vague, because what I want you to do is make sure your lawyer is talking to the 501c3 lawyer, and both of those lawyers are talking to the for-profit company and asking questions, about the structure of the business and whether or not there are compliance issues. But definitely it's possible for a nonprofit to charge for certain goods and services without losing their nonprofit status, but there are limits. And you need to be aware of those and have your lawyer advise you about what you're doing and whether or not that's a good idea, considering those limits on activity. So I'm not going to dive into like the specifics of that, because I don't know, is the for-profit company an L3C? What exactly is it that the 501c3 is doing, and so on. As far as you're concerned, and I think really like speaking to you and what your particular concern is here, you're probably the easiest person to advise. And for you, what I would do is have the 501c3 in your contract to provide the sustainable programming to the 501c3. Have the 501c3 fully indemnify you in your contract. So you need to have a written contract for the services that you provide, and it should state, I'm going to get paid X amount of dollars for delivering these services, and you're going to indemnify me. Like you're asking me to design curriculum based on your specifications and what you've said you want to do. It's not up to me as the independent contractor to determine whether or not what I'm delivering to you is going to mess with your 501c3 status. That's for you to work out, right? I'm here to deliver the result you asked for as an independent contractor, not to deliver a result that's necessarily compliant with all the regulations you have to comply with. So you give me the general specifications for the program that you want, along with any regulatory limitations that should be part of their ask of you, and then you design and deliver the programming and deliver that to the 501c3, and they indemnify you for any regulatory consequences that they may suffer from using the programming that you put in their hands. So I would require in my, if I were you, final summary, I would require an indemnification clause that's robust and deals with loss of 501c3 status if they use your programming, whether or not it's because they failed to disclose to you in the initial request for services all of the necessary parameters that they should have disclosed. Like whether or not that's the case, just under any circumstances conceivable, they're saying we agree to hold you harmless, waive all liability again, towards you, indemnify you, and defend you against any claims, including third-party claims that may result from our use of your programming. Ultimately, once you hand over the programming to them, they are accepting full responsibility for the use of that programming, and you're not responsible at all. So as the independent contractor here, again, you're the easiest person to advise, because really all you have to do is just create what they're asking you to create. You don't have to worry so much about how they use it and what the implications of that are.
That makes sense. Thank you very much.
You're welcome.
And Daniel did ask another question too, and I think you've actually partially answered it. So I'm going to paraphrase it a little bit. He's asking about, how to set up a good legal foundation to perform as a business consultant. And he mentions a couple specific things like liability, taxes, and legal contracts. And I know you probably are not allowed to advise on taxes specifically. At least, so my accountant always tells me he can't advise on legal. So I suspect it is reciprocated the other way.
No, it's not. I can advise on tax, but I refuse to because the last time I really took a serious look at the tax code was, I want to say 2010. When I was in law school. Tax code changes every year, so there's been like 11 years or so of changes to the tax code since I took a serious look at it. But like, I just got off the phone yesterday with a buddy of mine who went to Georgetown. After we both got out of law school, he went to Georgetown for an LLM in tax. He has a master's in tax, and he works for one of the big four accounting firms and does like international tax issues. When it comes to tax law, I strongly recommend having a tax lawyer and an accountant. There's an article on the Executive LP blog. If you go to executivelp.com, just search for tax lawyer, accountant, better together in the search bar. And that article will come up. And I had written this article some years ago about why tax lawyers and accountants are better when they work together. So it's not really an either or proposition, it's a both and proposition. But the essence of your question is, what do you need to do to cover all your bases, dot your I's and cross your T's and all of that? And the answer is really simple. You need outside general counsel. For a business that, like, I'm a one-man band, I'm a consultant, maybe you've got a team, you've got people who work for you, but really you're either a single member LLC or a sole proprietor, you're the only owner of the business, or maybe you and your spouse together or something like that. But as long as it's a really, really small operation, outside general counsel is going to be the right answer for you. The only alternative to that would be in-house counsel, and that's just not going to be affordable. It's going to be like killing a fly with a hammer. It's just overkill. So I would say outside general counsel is the right answer for you. And what does that mean? Well, outside general counsel is an independent contractor, an attorney who is there for you whenever you need them and who you regularly ask for advice, both strategic advice, in a prospective, preventive way, and also as things arise, that you have specific concerns about, you can bring those to your lawyer's attention. And because they have an intimate knowledge of your business that is born from a familiarity and a regular conversation with you about your business, they're going to be able to advise you about what you need to know in order to make the right decisions moving forward. More and more, general counsel, both in-house counsel for lawyers that are employees of a business and, there's a legal department and they work in kind of this larger business, as well as outside general counsel, the lawyers who are independently contracted to provide similar services. More and more, that role has become business strategist and legal advisor. It's not a pure legal role anymore. It used to be, but these days, businesses are expecting more of their lawyers. They're expecting for lawyers to align the legal services that they provide with the business goals of the business. So a really good general counsel attorney is not going to backseat drive in your company. He's not going to tell you how to run your business. He's not going to, try to play CEO. But he is going to give legal advice in a way that's designed to advance your legal strategy and move you closer towards your legal goals. We offer we offer two services that I think would be helpful for you, and I'm not going to sell you on them or anything or give you a pitch, but just to kind of let you know the kinds of things that you can be shopping for, whether from us or from a different lawyer of your choosing. The two services are Legal Lifeline, which we offer it either quarterly or annually. Annually, we charge $4,800 a year, and you get unlimited remote legal consultation, unlimited legal research, unlimited de minimis legal services. So anything that's 20 minutes or less that's a legal service is automatically included. An online client portal where basically any documents we review or touch for you, they get uploaded to the client portal for convenient, easy download, and just some really basic support stuff. We also offer a Profit from Legal Insight Workshop for businesses that are, under $1 million. It's a half-day workshop. We ask you to take our legal profitability scorecard online at profitfromlegal.scoreapp.com. And then it's a 40-question survey, and it talks about how you're using legal services in order to improve the profitability of your business, add value, reduce stress, and enhance resilience to basically prevent business disruption. And then in the Insight Workshop, we do a keynote on legal profitability, basically unpack what that concept is, how you can use metrics, these performance indicators, legal performance indicators, in order to evaluate the contribution that your lawyer is making to the profitability of your business. And then we do an unpacking of your scorecard with you and give you some custom insights and recommendations about the things that you should be working on with your lawyer in order to get the most bang for your buck. At the end of the day, it's about return on investment for your legal services. If you're spending $4,800 a year on legal, are you making that money back and then some because of the way you're using the legal services? So for example, I have a client who is on the legal Lifeline plan and called me up about a defamation issue. She had a couple of clients who were bad-mouthing her online and saying things that were provably untrue about the business. And typically a lawyer would have said, okay, well, let's file 2 defamation lawsuits. We'll file, a slander lawsuit or a libel suit, basically defamation suit, against each of these people for posting false reviews online that would damage your business reputation online. And typically the cost of a lawsuit for each of those lawsuits would be about $2,500. That's a good fair ballpark estimate for the lawyer to bring that. And, they would file the lawsuit, and then they would either win the lawsuit and get a judgment against the person and get the client paid as much as they could, or they would, more typically, they would settle the lawsuit. But they would use the litigation as a cudgel, basically, to get their way, to coerce the defendant into taking down the bad reviews, paying the judgment for damaging the business reputation, and so on. We took a different approach because our client is on the subscription-based service, and we have a great incentive to resolve these matters and deliver maximum benefit at lowest possible cost to the client so that they see the value in the service and continue the service. What we did was just contact directly each of these people and have a very polite, firm, but informal conversation with them and tell them, look, here's what's about to happen. You have 2 options. You can either take down the bad reviews, or you can get sued and still have to take down the bad reviews. Which would you like to do? And they took down the bad reviews. And resolving that whole situation took me less than an hour. And because I didn't have to file a lawsuit to get it done, I saved my client about $5,000 in litigation expense.
That's huge.
And she told me, she was like, I've been dealing with this myself for 3 weeks. And it's been stressing me out. It's been a huge pain in the ass for 3 weeks. And I was like, well, call me sooner next time. I don't know what to tell you. I got it done in less than an hour and saved you $5,000. She was super happy. And so in that 1 hour, I was able to basically deliver enough value to her that it paid for the service for the whole year. Everything else that I did for her, and it's, not been minimal. It's been quite a bit of stuff we've been able to do for her this year, has just been icing on the cake because the service has already paid for itself. But we didn't stop there because, being able to profit from legal is not just about, can I sue someone and make some money? I mean, that's in a very cynical way. That might be a way to think about it. But we want you to profit has 2 definitions. One is to earn more than you spent, and the other is to benefit. Generally, it's something is profitable, it's beneficial to you. And so we want to be of as much benefit and for you to derive as much benefit as possible from legal. And so it wasn't enough for us to defuse one bad situation. We wanted to go a step further and prevent that from ever happening again. So we advised the client about changing her client intake process and her dispute resolution processes to set clearer expectations for the client, communicate better with the client about what the source of that particular dispute was, to make it so that there was a process in place that if a customer has a problem with goods or services that they've purchased from the business, they know what the clear dispute resolution procedure is, and they have to go through that process, and they agree to go through that process when they sign their client intake paperwork. They agree to go through that process if they have a problem before filing a lawsuit. Similar to what you might see in an arbitration clause or a mediation clause in a contract, where you can say, before anybody sues anybody over this contract, you agree to participate in binding arbitration or mediation to try to resolve the dispute, which is typically much less expensive than litigation.
And again, I heard you go back to contract. That
Yeah.
was very sound advice. And what I also heard there is that by being proactive in choosing whoever you're going to choose for counsel, make sure that they are working on a consultative base, not just working for you when you have a problem.
Yeah, absolutely. Like having someone that's always on. The service is always on. It's there. It's not just reactive. It should be responsive to you, but it should not be a reactive service. You should not wait until you have a problem, and you surely should not wait until you have a crisis. The three phases of a crisis are risk, problem, crisis. And everybody has risks all the time. There's always risks all the time. You can't do anything about that. You cannot, completely mitigate all risk. You can't eliminate risk in business. That's a pipe dream. But you can prevent those risks and manage those risks and prevent them from becoming problems. And if something does happen to slip through your preventive efforts and it does manifest as a problem, that just means that things are not working as intended. Something went wrong. There should, in the early phases of that, be a way to defuse the situation, just like we did with the defamation claim. Have the conversation, engage with the other person, work to resolve whatever dispute has arisen, defuse that, because once it goes unresolved for a period of time, and additional consequences start to pile up, or you trigger some regulatory compliance issue or some other thing, now you've got a crisis. You've either got the government saying you violated this regulation, we're going to fine you, or someone has filed a lawsuit, and even winning the lawsuit would cost you a lot of money. It's expensive to win lawsuits. So thinking, well, I'm doing what I should be doing legally, and if I get sued, I'll just win the lawsuit. Well, that's great. I'm glad you have that kind of optimism and confidence, but really you need to realize that it's expensive to win a lawsuit, even if you have the high ground. So the best way to litigate is to not litigate. It's like saying the safest way to have sex is to, practice abstinence, right? It's kind of cheating, but it's still true that the safest way to deal with lawsuits is to not have them. And it's the best way to win every single time. And it's just to not have to fight. The preparation that you do in advance and the opportunities that you seize in order to resolve risks before they become problems and solve problems before they become crises, those are the big victories in the battles that you're going to fight. You're always faced with those risks, but you need to have a lawyer who's on your side. The services are always on. It's good to be able to talk to your lawyer about the cost projections for legal and then budget for that. It's much less painful to budget for legal and then maybe end up with a surplus because you didn't use everything that you had planned to have to pay for. Maybe you didn't draft as many contracts that year, and so you had money in your legal budget left over. Well, that's great. But it's much less painful to do it that way than to not plan for legal expenses and then have them. Because then you're scrambling. You're really going to feel the pinch. You're going to have to rob Peter to pay Paul, as it were. And that's a much harder thing to do. So a subscription-based legal service will allow you to budget for legal services better. That's why we charge a value-based fee rather than an hourly fee. That's why we use subscription-based models, as we want our clients to be able to budget for their legal services. That's a big component of affordability. And the other component of affordability is realizing how to use legal services in order to benefit most from them and improve the profitability of your business, because profit is what happens when you get everything else right in your business. Yvonne Chouinard said that, and we believe that that's absolutely true. So we see our job as helping you get everything else right, because that's where profit comes from.
So no, I think that some people may be thinking, when you say subscription-based service, they might be thinking of that MLM that has people out networking everywhere. What you provide is different. Okay.
Yeah, I hate MLMs. I hate that. Like that just
Well,
made my skin crawl just with you saying MLM.
No, I
was just like,
understand,
ugh.
but that is a little bit how that one is viewed. Okay. And I'm not throwing out any names for liability reasons.
Yeah.
But
we don't do any of that.
Yeah, absolutely. So what does your onboarding process look like when a client comes in, they've done all of that stuff? Okay. What does it look like? How do you determine what they
setup?
need? Yeah.
Oh,
well, just
yeah.
how do you determine what they need? I mean, because the other company that I referred to, it's basically you sign up and then you call when you need, and sometimes you're referred to an online template library. And
no templates, no online templates or anything like that. That's another thing that it makes my skin crawl. No, we set up. Okay, so after I think you're asking about post setup. How is the service implemented? I thought you were asking me about the onboarding process for how you get signed up to the service. Which is just like I said, you go through that consultation, we assess what you need, figure out the cost, scale it to match your business, and then you're off to the races. Once you're signed up for the service and we're delivering the service, the first thing that we do is in our CRM system on our end, we put in, we have a task list. It's just automated, and we put in all the dates that you're going to receive reminders to schedule a legal check-in with your lawyer. That's the first thing. Is gotcha. we don't wait for you to be responsive to us. Every single week you'll get a reminder from us. For as long as your outside general counsel runs, you'll get an email from us saying, don't forget to schedule a weekly check-in with your lawyer this week. Just take 20 minutes, talk to your lawyer about what's going on, and there's a Calendly link in there. You click that, you automatically schedule it at a mutually convenient time, and then the whole service revolves around those 20-minute check-ins. It's all about the regularity of interface. Now, I have clients that will skip their weekly check-ins for 3 weeks or a month, and then they'll schedule one, and that's okay. I don't give them a whole bunch of guff about that. I just accept that that's how frequently they want to engage with the service, but we do try to be proactive. Also, as we encounter things that, correlate to the notes that we've taken for the client, we take notes on what the client is interested in, what their goals are, what they're trying to accomplish. And as we encounter material, whether it be continuing legal education material, changes in the law that could affect them, other things, as we become aware of those things, we send out notifications to the client. Hey, are you aware that this law changed in your jurisdiction regarding this thing that we know you're working on? Are you tracking that? And we ask them about those kinds of things. But really, it's the 20-minute check-ins that drive the service, and the people who get the most out of the service are the ones who regularly schedule FaceTime with their lawyer. They tell the lawyer, this is what I did this week, this is what I'm working on, these are the concerns I have, and the lawyer knows them on a first name basis, knows what their goals are, know what's going on in their business. I have a couple here that lives locally, and their business is pre-revenue. They haven't opened their doors yet. They've been doing the build out in this old Victorian historic building for a business, and it's in one of these large blocks. All the Victorian buildings are like wall to wall. They all share walls for like the whole city block, and the building 2 doors down caught fire. There was a grease fire in a kitchen in a bar, and so they called me up. It was like a Saturday, I want to say Saturday afternoon. They called me up and they were like, yeah, so the bar down 2 doors down is on fire, and the fire department's been out there since 7:30 this morning trying to put it out. What do we need to do in terms of like contacting the insurance company or, tracking all of this, what's going on? And because I knew that their lease was in flux, that they had all these other issues, they had these other things that were going on, I could really speak knowledgeably and intelligently to their unique situation and circumstances without like a whole lot of catch up or, I don't know, let me research that and get back to you. It's because I knew what was going on with their business that I was able to be very responsive to their needs. And ultimately, good news, the fire was contained. They had a little bit of water. It perked out of the basement, and they had minor smoke damage. So it all worked out for my client. But it was just, it was a great interaction, and we were catching up, over the cell phone. They called me the next day, let me know how everything was going. And it was just like, the interaction was more like talking to a friend about what's going on in their life than it was like, oh, let's call the lawyer, and you have to be really prepared and have everything in order. It's designed to be more like, we're your legal department. We're the boys in legal just down the hall, basically is the way it's supposed to feel. And we're really obsessed with the client experience. So everything that we can do in order to promote good client interactions, to stay in front of our clients' faces, to stay knowledgeable about what's going on with them, we do. So everything does revolve around those 20-minute check-ins.
That's amazing. I did not know what your onboarding was. Maybe I should have said client experience, but I didn't know what it was. And I just really wanted you to have an opportunity to differentiate yourself from those other plans that kind of claim that, hey, we're your 24-hour lawyer, because it's completely different experience.
Yeah. Well, they're working on an hourly model. See, it comes down to the business model that the lawyer uses, and all of the client experience differences are the result. They're not in and of themselves a cause, right? They are the result of a difference in business model. Our business model is you pay one fee for the year, service is always on, and we see it as our job to deliver value that's equal to or greater than what you've paid us. We want you to be happy. We want to be able to prove to you. I had a client that paid me just under $17,000 during a single year of legal service. And in one weekend, we delivered over $50,000 of value to that client. That was a measurable benefit. And so that's our goal, is to look at the numbers, look at the metrics, talk to the client and say, you paid us this, but we delivered this. That's so much higher. And so would you like to renew? And for the client to go, hell yeah, let me renew. We want it to be a hell yes kind of feeling. We don't want people to feel reluctant to call their lawyer, or like, oh, I got to talk to the lawyer today. We don't want that. We want it to be a good thing. And the difference is, if you are hiring a lawyer and you're paying the average annual or the average hourly rate for outside general counsel service, which in the United States right now it's about $235 an hour. So if you have to pay $47 for a 12-minute phone call because you're billing hourly, are you going to pick up the phone?
No.
I mean, odds are no, not unless your hair's on fire. You're going to wait for the crisis. And that is completely the opposite of what you should do. You should not wait for the crisis. But if you're billing, if someone feels like they're in a cab with the meter running every time they talk to you, their goal is to get out of the cab as soon as possible and to interact with you as little as possible, which is an incentive to not interact with the lawyer. And that's the opposite of the incentive that we need to provide. The incentive we need to provide is the incentive to interact with your lawyer early and often. So to do that, you kind of have to chuck the billable hour. So that's largely what we've been about, is finding ways to deliver services to clients that is based on a value-based fee, that doesn't involve the billable hour, that allows the client to budget for legal services and focuses on metrics to show the client that they're getting more in terms of value than what they're paying for.
And that leaves us on an excellent note. Noel did a legal poverty podcast for me last September. You guys can find it on my website, dcavirtual.com/podcast, or you can get it on Apple Podcasts, Google, Pandora, Deezer. It's pretty much on every major podcast station out there. So go ahead and bookmark that, like us. Noel, I appreciate you being on here today. All of our guests, I appreciate you for the questions that you've submitted. We'll go ahead and notify you when we post this podcast, as well as the video. Thank you, everyone.
Thank you for joining us for today's Nurture Small Business, Creating a Thriving Space podcast. Learn more about your host at DCAvirtual.com or by emailing her directly at denise@dcavirtual.com.